Hello and welcome to today's webinar, Who's Responsible for Information in the New Data World? 5 Keys for Good Data Governance. I'm Teresa Resick, Director of Webinars here at AIM, and AIM is your host and producer of today's event. And with me today are Mimi Dion, an independent consultant and data scientist, and Graham Austin with Crown Records Management. And Crown Worldwide Group is the underwriter of today's webinar, and we thank them for their support. And thank you for taking the time to join us today. And before we get started, I just want to give you a few pointers for viewing today's webinar. You can download a PDF of the presentation at any time. Just look to the bottom of your screen in the Resources tab, and you'll see the link there to download the presentation. Feel free to ask questions throughout the hour using the Ask a Question feature, and we will hold your questions until the end, where we will have about 5 or 10 minutes to answer them, but you can also use this feature to comment or ask for technical assistance. At the end of the webinar, we would greatly appreciate if you would take the brief survey, tell us how we did today, and suggest future topics for us to cover. The link to that survey is also in the Resources tab that's at the bottom of your screen. And at the end of the webinar, I'll remind you about this again, but feel free just to click that link now. It will open in a new window, and you can just save that for when the webinar is over with. And this webinar is being recorded, and it will be posted to AIM.org's Webinars On Demand library in just a few days. And right now, I just want to take a few moments to introduce our featured speakers today. Very pleased to have these two people with us. Graham Austin has over 20 years of experience in senior management positions, and Graham is now a business development manager for information management at Crown Worldwide. Previously, he was Managing Director at STP Information Services Limited, the market leader in benchmarking, publishing, and events in the capital markets technology arena. In January of 2010, Graham was elected as Chief Executive of ISITC Europe, a trade association dedicated to promoting operational efficiency in the capital markets arena. And our featured presenter today is Mimi Dion, and Mimi is a data scientist who leverages best records and information governance practices with more than a decade of experience. She drives cross-functional teams through all phases of the project management lifecycle. Mimi helps organizations understand complex business challenges, transforms processes and systems, and leads multifaceted technical initiatives. She serves an integral role on successful, high-profile electronic records and information governance implementations within the medical, government, legal, telecommunications, and energy sectors. So right now, I am going to turn things over to Mimi Dion to begin discussing who's responsible for the data. Mimi?
Hello, everyone. Good to be with you. As I was asked to provide some background on data privacy management in anticipation of Crown's presentation today. So thank you for your kind attention as I quote and or summarize the following commentary from the EU Council on the Data Protection Directive. As you review the topics we'll discuss in the next 30 minutes, let me include that under EU law, data protection was regulated for the first time by the Data Protection Directive, and I will shorten that to the DPD for almost the rest of the presentation. Data protection has been acknowledged as a fundamental right. The DPD, however, draws on the possibility of adding on instruments of protection. One of the principal sources for the presentation this morning, the Handbook on European Data Protection Law, reminds us that the right to data protection is not an absolute right. It must be balanced against other rights. Special categories of personal data which deserve higher protection may only be processed for health-related purposes where necessary to achieve those purposes for the benefit of individuals and society as a whole. In particular, in the context of the management of health or social care services and systems. Included is the processing by any central national health authorities for the purpose of quality control, management, information, and the general national and local supervision of the health or social care system, as well as ensuring continuity of health or social care and cross-border health care or health security, monitoring and alert purposes for archiving, historical, statistical, or scientific purposes, as well as for studies conducted in the area of public health. When the Council of the EU released its latest comments on the DPD last month, of special interest was transporter data flows. The report advocates for cross-border flows of personal data to and from countries outside the Union and international organizations because they are necessary for the expansion of international trade and cooperation. Of course, the increase in these flows has raised new challenges and concerns with respect to the protection of personal data. However, when personal data are transferred from the Union to controllers, processors, or other recipients in third countries or to international organizations, the level of protection of individuals guaranteed in the Union by this regulation should not be undermined, including in cases of on-route transfers of personal data from the third country or international organization to the controllers, processes in the same or another third country or international organization. In any event, transfers to third countries and international organizations may only be carried out in full compliance with this regulation. So when I say who is responsible for this data, these roles that we were just talking about a moment ago, what do I mean by that? Well, the EU Council to date has agreed that the roles are as follows. A natural person is a data subject. The latest comments include a special focus on the protection of children, to wit, children deserve special protection of their personal data, as they may be less aware of risks, consequences, safeguards, and their rights in relation to the processing of personal data. This concerns especially the use of personal data of children for the purposes of marketing or creating personality or user profiles and the collection of child data when using services offered directly to a child. Under EU law, a controller is defined as someone who, alone or jointly with others, determines the purposes and means of the processing of personal data. A controller's decision lays down why and how data shall be processed. The definition of controller in the DPD provides that there might also be several legally separate entities who together or jointly with others act as a controller. This means that they decide together to process data for a shared purpose. This is legally possible, however, only in cases where a special legal basis provides for processing the data jointly for a common purpose. A processor is defined under EU law as someone who processes personal data on behalf of a controller. The activities entrusted to a processor may be limited to a very specific task or context, or may be quite general and comprehensive. If the power to determine the means of processing is delegated to a processor, the controller must nonetheless be able to interfere with the decisions of the processor regarding the means of processing. Overall responsibility still lies with the controller, who must supervise the processors to ensure that their decisions comply with the data protection law. A contract forbidding the controller to interfere with the decisions of the processor would, therefore, probably be construed as resulting in joint controllership, with both parties sharing the legal responsibility of a controller. Should a processor not honor the limitations of data use as prescribed by the controller, the processor will have become a controller, at least to the extent of the breach of the controller's instructions. This will most likely make the processor a controller who acts unlawfully. In turn, the initial controller will have to explain how it was possible for the processor to breach its mandate. For the sake of clarity and transparency, the details of the relationship between a controller and a processor should be recorded in a written contract. Having no such contract is an infringement of the controller's obligation to provide written documentation of mutual responsibilities and could lead to sanctions. Recipient is a broader term than third party. A recipient is a natural or legal person, a public authority, an agency, or any other body to whom data are disclosed, whether a third party or not. The recipient may either be a person outside the controller or processor, this would then be a third party, or someone inside the controller or processor, such as an employee of another division within the same company or authority. Meanwhile, a third party is any natural or legal person, public authority, agency, or any other body other than the data subject, the controller, the processor, and the persons who, under the direct authority of the controller or the processor, are authorized to process the data. This means that persons working for an organization which is legally different from the controller, even if it belongs to the same group or holding company, will be or belong to a third party. On the other hand, branches of a bank processing customer accounts under the direct authority of their headquarters would not be third parties. The distinction between recipients and third parties is important only because of the conditions for lawful disclosure of data. The employees of a controller or processor may, without further legal requirements, be recipients of personal data if they are involved in the processing operations of the controller or the processor. On the other hand, a third party, being legally separate from the controller or processor, is not authorized to use personal data processed by the controller, unless on specific legal grounds in a specific legal case. Third-party recipients of data will, therefore, always need a legal basis for lawfully receiving personal data. In the interest of time, I would like to move forward to the next through the next two slides and we will come back to these in the Q&A, I think. But I would like to simply share with you very quickly how we are designing. I work for a global company, and we have already started to think around who manages data in the workplace. And as these slides become available to you in the next few days, you'll have the luxury of going back and looking at this a bit more closely yourself. But I am recommending that in the case of within your company, you start to create a RACI chart that outlines, responsibilities, organizational roles, custodianship, and a RACI chart is a great tool in which to facilitate that discussion. And therefore, embed in an overall, if you're requested, an overall procedure for senior leadership, how the data will be handled. These are just simple visualizations, simple recommendations that you can take yourself and further embellish to describe to senior leadership your work in the next 6 months, the next 9 months, the next year, as the data protection directive becomes more firm and solidified. Let's move on to the principles of EU data protection policy. The Data Protection Handbook clearly states that the right to data protection is likely to conflict with the right of freedom of expression. Member states are required to provide for a number of limitations in relation to the protection of data and, therefore, in relation to the fundamental right to privacy. The limitations must be made solely for journalistic purposes or the purpose of artistic or literary expression, which fall within the scope of the fundamental right to freedom of expression. The Data Protection Directive permits the retention of data for scientific research once they are no longer needed for the initial purposes of their collection. Furthermore, the subsequent use of personal data for scientific research shall not be considered an incompatible purpose. National law must develop safeguards when its citizenry demands them. The EU has several legal instruments that protect intellectual property. In particular, copyright IP covers not only literary and artistic property, but also patent, trademark, and associated rights. When you, the members of our audience, reach out to Crown for an information management solution, IP rights, at least from a retention point of view, will be packaged into the retention management guidance, and I'm sure Crown will address this later during its presentation. Under EU law, the right of access to documents is guaranteed by Regulation 1049/2001 regarding public access to European Parliament, Council, and Commission documents. Article 42 of its Charter and Article 15.3 of the Treaty on the Functioning of the EU have extended this right of access to documents of the institutions, bodies, offices, and agencies of the Union, regardless of their form. As I researched this presentation, a wonderful blog called EU Law Analysis, Expert Insight into EU Law Developments, became one of my favorite sources. You can find it at eulawanalysis.blogspot.com. PhD students, trainees at the CJEU, researchers at Statewatch, another fabulous resource, senior lecturers, journal editors, and professors of law all contribute to this blog, edited by Steve Pierce, professor of EU Law and Human Rights Law at the University of Essex. Personal data must be processed lawfully, fairly, and in a transparent manner in relation to the data subject. It must be collected for specified, explicit, and legitimate purposes, and not for the process in a way incompatible with those purposes. Further processing of personal data for archiving purposes in the public interest, or scientific, statistical, or historical purposes shall not be considered incompatible with the initial purposes. Adequate, relevant, and not excessive in relation to the purposes for which they are processed. accurate, and where necessary, kept up to date. Every reasonable step, in other words, must be taken to ensure that personal data is accurate, having regards to the purposes for which they are processed, are erased, or rectified without delay, kept in a form which permits identification of data subjects for no longer than is necessary for the purposes for which the data are processed. Personal data may be stored for longer periods insofar as the data will be processed for archiving purposes in the public interest or, of course, as mentioned before, scientific, statistical, or historical purposes to safeguard the rights and freedoms of the data subject. Processing of personal data shall be lawful only if and to the extent that at least one of the following applies. The data subject has given unambiguous consent to the processing of their personal data for one or more specific purposes. For the performance of a contract to which the data subject is party, or in order to take steps at the request of the data subject prior to entering into a contract. For compliance with the legal obligation to which the controller is subject, order to protect the vital interests of the data subject or another person, and for the performance of a task carried out in the public interest or in the exercise of official authority vested in the controller, or for the purposes of the legitimate interests pursued by the controller or by a third party, except where such interests are overridden by the interests or fundamental rights or freedoms of the data subject, which require protection of personal data, in particular where the data subject is a child. The principle of purpose, specification, and limitation means that the legitimacy of processing personal data will depend on the purpose of the processing. The purpose must have been specified and made manifest by the controller before the processing of data starts. Under EU law, this must be done either by declaration, in other words, by notification, to the appropriate supervisory authority, or at the least by internal documentation which must be made available by the controller for inspection by the supervisory authorities and accessed by the data subject. The processing of personal data for undefined and or unlimited purposes is unlawful. The principles of data quality must be implemented by the controller in all processing operations. Only such data shall be processed as is adequate, relevant, and not excessive in relation to the purpose for which they are collected and or further processed. A controller holding personal information shall not use that information without taking steps to ensure with reasonable certainty that the data are accurate and up to date. The obligation to ensure accuracy of data must be seen in the context of the purpose of data processing. The principle of limited retention of data makes it necessary to delete data as soon as they are no longer needed for the purposes for which they were collected. Exemptions from the principle of limited retention must be set out by law and need special safeguards to the protection of data subjects. Fair processing means transparency of processing, especially vis-a-vis the data subjects. Controllers must inform data subjects before processing their data, at least about the purpose of processing and about the identity and address of the controller. Unless specifically permitted by law, there must be no secret, no covert processing of personal data. Data subjects have the right to access their data whenever they are processed. Meanwhile, accountability requires the active implementation of measures by controllers to promote and safeguard data protection in their processing activities. Controllers are responsible for the compliance of their processing operations with data protection law. Controllers should be able at any time to demonstrate compliance with data protection provisions to data subjects, to the general public, and to supervisory authorities. So let's discuss very briefly the rules and the impact of EU data protection policy. The original text of the DPP says consent as a legal basis for processing personal data must be free, informed, and specific. Consent must have been given unambiguously. Consent may either be given explicitly or implied by acting in a way which leaves no doubt that the data subject agrees to the processing of his or her data. Processing sensitive data on the basis of consent requires explicit consent. Consent can be withdrawn at any time. What the EU Council has agreed upon to date In order to safeguard that consent has been freely given, consent should not provide a valid legal ground for the processing of personal data in a specific case where there is a clear imbalance between the data subject and the controller, and this imbalance makes it unlikely that consent was given freely in all the circumstances of that specific situation. Consent is presumed to be not freely given if it does not allow separate consent to be given to different data processing operations, despite it is appropriate in the individual case, or if the performance of a contract is made dependent on the consent. A transfer or a category of transfers of personal data to, say, a third country or an international organization may take place only on condition that the transfer is necessary for the performance of a contract between the data subject and the controller, or the implementation of pre-contractual measures taken at the data subject's request. EU law then explicitly mentions another criterion for making data processing legitimate, namely if it is necessary for compliance with a legal obligation to which the controller is subject. This provision refers to controllers acting in the private sector. The legal obligations of public sector data controllers fall under Article 7E of the directive. There are many cases in which private sector controllers are obliged by law to process data about others. For example, physicians and hospitals have the legal duty to store data about the treatment of patients over several years. Employers must process data about their employees for reasons of Social Security and taxation, and businesses must process data about their customers for reasons of taxation. Under EU law, the processing of personal data is lawful if it is, quote, necessary in order to protect the vital interests of the data subject, end quote. Such interests, which are closely related to the survival of the data subject, could be the basis for the legitimate use of health data or of data about missing persons, for example. A transfer of personal data should equally be regarded as lawful where it is necessary to protect an interest which is essential for the data subject or another person's vital interests, including physical integrity or life, if the data subject is incapable of giving consent. It should also be for union or national law to determine whether the controller performing a task carried out in the public interest or in the exercise of official authority should be a public authority or another natural or legal person governed by public law, or by private law, such as a professional association, where grounds of public interest so justify, including for health purposes. In order to ascertain whether a purpose of further processing is compatible with the purpose for which the data are initially collected, the controller should take into account any link between the purposes and the purposes of the intended further processing, the context in which the data have been collected, including the reasonable expectations of the data subject as to their further use, the nature of the personal data, the consequences of the intended further processing for data subjects, and appropriate safeguards. Restrictions on specific principles and on the rights of information, access, rectification, and erasure, or on the right to data portability, the right to object, measures based on profiling, as well as on the communication of a personal data breach to a data subject, and on certain related obligations of the controllers may be imposed by union or member state law to safeguard public security, including the protection of human life. EU law contains a detailed regime for processing categories of data that reveal racial or ethnic origin, political opinions, religious or philosophical beliefs, trade union membership, or information on health. The processing of sensitive data is prohibited on principle. There is, however, a list of exemptions to this prohibition, which can be found in the directive. These exemptions include explicit consent of the data subject, vital interests of the data subject, legitimate interests of others, and public interest. The principles of data protection should apply to any information concerning an identified or identifiable natural person. Data including pseudonymized data, which could be attributed to a natural person by the use of additional information, should be considered as information on an identifiable natural person. To determine whether a person is identifiable, account should be taken of all the means reasonably likely to be used, either by the controller or by any other person to identify the individual directly or indirectly. To ascertain whether means are reasonably likely to be used to identify the individual, account should be taken of all objective factors, such as the cost of and the amount of time required for identification, taking into consideration both available technology at the time of processing and technological development. Any processing of personal data should be lawful and fair. It should be transparent for the individuals that personal data concerning them are collected, used, consulted, or otherwise processed, and to which extent the data are processed or will be processed. The principle of transparency requires that any information and communication relating to the processing of this data should be easily accessible and easy to understand, and that clear and plain language is used. Individuals should be made aware on risks, rules, safeguards, and rights in relation to the processing of personal data and how to exercise his or her rights in relation to the processing. In particular, the specific purposes for which the data are processed should be explicit and legitimate and determined at the time of the collection of the data. As soon as the controller becomes aware that a personal data breach, which may result in physical, material, or moral damage, the controller should notify the breach to the supervisory authority without undue delay, and where feasible, within 72 hours. Where this cannot be achieved within 72 hours, an explanation of the reasons for the delay should accompany the notification. The individuals whose rights and freedoms could be severely affected by the breach should be notified without undue delay in order to allow them to take the necessary precautions. The notification should describe the nature of the personal data breach, as well as recommendations for the individual concerned to mitigate potentially adverse effects. The communication of a personal data breach to the data subject should not be required if the controller has implemented appropriate technological protection measures and that those measures were applied to the data affected by the personal data breach. Such technological protection measures should include those that render the data unintelligible to any person who is not authorized to access it, in particular by encrypting the personal data. Due consideration should be given to the circumstances of the breach, effectively limiting the likelihood of identity fraud or other forms of misuse. Moreover, such rules and procedures should take into account the legitimate interests of law enforcement authorities in cases where early disclosure could unnecessarily hamper the investigation of the circumstances of a breach. Under EU law, the secure processing of data is further safeguarded by the general duty on all persons, controllers, processors to ensure that data remains confidential. To ensure transparency, the controller should be obliged to explicitly inform the data subject on the legitimate interest pursued and on the right to object, and also be obliged to document those legitimate interests in order to ensure a consistent level of protection for individuals throughout the Union and to prevent divergences hampering the free movement of data within the internal market. A regulation is necessary to provide legal certainty and transparency for economic operators, including micro, small, and medium-sized enterprises, and to provide individuals in all member states with the same level of legally enforceable rights and obligations and responsibilities for controllers and processors to ensure consistent monitoring of the processing of personal data. Before starting to process personal data, the controller must, at the very, very least, inform the data subjects about the identity of the controller and the purposes of the data processing, unless the data subject already has this information. Where the data are collected from third parties, the obligation to provide information does not apply if the data processing is provided for by law, provision of information proves impossible or would involve a disproportionate effort. Before starting to process personal data, the controller must additionally notify the supervisory authority of the intended processing operations or have the processing internally documented by an independent personal data protection official if national law provides for such proceedings. The supervisory authority must check processing operations which may cause specific risks to the rights and freedoms of the data subject due to either the purpose or the circumstances of processing before processing begins. National law must determine which processing operations qualify for prior checking. Such checking may result in processing operations being prohibited or in order to change features in the proposed design of the processing operation. Very briefly, I'm going to move on to a quick slide about the mobile workforce. Within the commentary that was posted by the EU Council, there was certain language that was used as cautionary language around mobile devices. When using online services, individuals may be associated with online identifiers provided by the devices, applications, tools, and protocols such as IP addresses or cookie identifiers. This may be traces which, when combined with unique identifiers and other information received by the servers, may be used to create profiles of the individuals and identify them. ID numbers, location data, online identifiers, or other specific factors as such should not be considered as personal data if they do not identify an individual or make an individual identifiable. The processing of data to the extent strictly necessary for the purposes of ensuring network and information security, in other words, the ability of a network or an information system to resist at a given level of confidence, accidental events or unlawful or malicious actions that compromise the availability, the authenticity, the integrity and confidentiality of stored or transmitted data, and the security of the related services offered by or accessible via these networks and systems by public authorities, the Computer Emergency Response Team, the Computer Security Incident Response Teams, providers of electronic communication networks, or providers of security technologies and services, constitutes a legitimate interest of the data controller concerned. This could, for example, include preventing unauthorized access to electronic communication networks and malicious code distribution and stopping denial of service attacks. This processing of personal data strictly necessary for the purposes of preventing fraud also constitutes a legitimate interest of the data controller concerned. And that's something that we're currently debating at work. Do we use company-issued devices? Do we create our own BYOD? And how does the data protection directive influence the creation of the BYOD policy? To sum up, the Council has reached a partial general approach on specific issues of the draft regulation setting out a general EU framework for data protection on the understanding that nothing is agreed until everything is agreed, as the European Council's Council of the European Union wrote so elegantly last month. Derogating from the prohibition on processing sensitive categories of data should also be allowed when provided for in union or member state law, and subject to suitable safeguards so as to protect personal data and other fundamental rights, where grounds of public interest so justify, in particular processing data in the field of employment law, social security and social protection law, including pensions and for health security, monitoring and alert purposes, the prevention or control of communicable diseases and or serious threats to health or ensuring high standards of quality and safety of healthcare and services. Personal data concerning health should include data pertaining to the health status of a data subject, which reveal information relating to the past, current, or future physical or mental health of the data subject, including information about the registration of the individual or the provision of health services. A number, a symbol, or particular assigned to an individual to uniquely identify the individual for health purposes. Information derived from the testing or examination of a body part, including genetic data and biological samples, or any information on, for example, a disease, a disability, a disease risk, med history, biomedical state of the data subject independent of its source, such as, for example, from a physician or other health professional, a hospital, a medical device, or an in vitro diagnostic test. To conclude, I wanted to offer you not only a summary of the recent commentary of the data protection rights document, but also to transition or segue into the Crown Records Management presentation, This is a framework that we have been informally discussing in my workplace, where the different information management pieces, how they fit within their own framework and then within the organization as well. And the agreement we have so far is that document control is a subset of the records management lifecycle. And we've spoken a bit about retention management and the need for limited retention and the use of extensive retention where it is appropriate. Where those retention expectations, where the data privacy expectations, how they fit within the enterprise content management portfolio, as well as the information governance portfolio, which includes data privacy management, that is up to, this approach is up to extensive debate. And I'm looking forward to the Q&A period. I hope we have some discussion around it if we have time. But without further ado, I will leave you with this perspective as Crown embarks on its own presentation, and I thank you for your kind attention as always.
Thank you very much indeed, Mimi. We very much appreciate a very thorough run through of the EU data privacy regime that we're going to be facing up against very shortly. What I plan to do very briefly is to take a step back and talk about how we can construct an effective data governance framework which addresses all of the data privacy issues that Mimi just described, but also covers all the other kinds of data that exist inside your business. The basic idea is that if you increase the levels of control and efficiency within your organization through a handful of simple steps, then greater operational efficiency takes place, you can achieve cost savings and a better run business. And of course, inevitably, it's going to be a classic case. It's easy for me to say the complexity lies in the execution, which we won't be covering today, obviously. But I wanted to spend a few minutes just giving you a highlight of the key areas that you need to focus on. The first thing to say is a cliche, for which I do not apologize whatsoever. You can't manage what you can't measure. Until you know what data actually resides inside your organization, you literally cannot manage it, let alone any data privacy issues relating to EU regulation. So, the first thing we recommend is to carry out some kind of a data audit. You need to understand what data you have stored and in what formats. So, that filing cabinet in the corner of your office is part of the data set that you need to address. Equally, the email servers that you use, the business systems and databases, all of them contain information, as well as, say, servers containing document scans. You need to understand the full extent of what data you have inside your organization before you can, A, protect yourself from the EU data privacy issues, and B, run an efficient organization. So, that's the first thing that you really need to consider. On top of that, you need to think about how important it is to gain access to that information in a short or long time frame. So, some information you'll no doubt want in real time, typically today's emails being a classic and simple example of that. But equally, there'll be some information which your organization needs to retain for a length of time to be defined, but you don't need to have it available on your desktop from the 0-second hour. It could be available through an archive if you waited a few minutes, hours, or weeks, depending on the requirement. And equally important to knowing what your data is and where it is, you also need to know when you want to get rid of it. Deleting data is a wonderful thing, because not all data needs to live forever. There are mandatory minimum terms of storage for all sorts of kinds of data, but not for all data, and you need to be aware of that. To ensure that you have a governance framework that is worthy of the name, you need to have some policies in place. Quite simply, the policies define how you're going to use the data that you've just unearthed and uncovered through your data audit. You need to be able to distinguish between two kinds of data, what I call useful data and what I also call useless data. To borrow a term from lean consultancy, there is a notion of energy sapping in Lean, and I think it applies to data as well. Useless data that has no business value is not just useless to you as an individual, it also costs money to maintain for your organization, money that I'm sure could be better spent on useful information. So business value is often a very good testing factor to decide and distinguish between useful and useless data. If it has business value, there will be an incremental improvement in the quality and quantity of your business, either by increasing revenues or maintaining cost base. If, however, the data that you're storing doesn't meet either of those requirements, maybe it counts as useless data. You need to think through that very carefully and then decide precisely how you're going to delete or remove it. And having discovered what your data is and how it's going to be maintained, stored, and deleted, it would be a really good idea if everyone in your organization knew what the rules of engagement were. So we need to be sure that your staff across the entirety of your organization have sufficient training to understand what is expected of them. I'll throw out a stat which I find quite shocking. That is that 80% of data breaches stem from human error. And that is a quite incredibly high statistic, which means that it is your staff who are most likely to be the causes of data breaches if they are unaware of A, what a data breach constitutes, and B, the significance of what that human error could mean. With the impending EU data regulation coming along, that number is quite simple. 5% of your global turnover could be at risk due to a fine or 100 million euro, whichever is the greater. That's a not insignificant sum for a business to be hit with. And that's global turnover. Another interesting risk relating to the EU data legislation is that it's the EU citizen whose data is being protected, and it doesn't matter where that data is stored. So, whereas, say, in the UK data privacy regime right now, you have to reside in the UK, if the server is in the Cayman Islands, Alaska, Antarctica, anywhere on the planet where it is storing personal data on EU citizens, the organisations who own those servers need to conform to the EU rules. This is much bigger and broader than any existing data privacy rules that exist as far as I can tell. And the other key thing to do is to make sure that it's not just your structured data in your databases and your business systems, which are relatively easy for you to manage and control, given that they exist inside some kind of structured system. Email is probably the most classic unstructured data, along with pieces of paper and filing cabinets. You need to be able to ensure that your staff understand the implications of storing data in unstructured ways and are also able to manage and control that personal data that's contained in those unstructured formats. Well, maybe describe a number of the different categories of ways that individuals and entities can interact with personal data on an EU level. For a business, there is the principle of data ownership to consider. For policies to be effective, they need to be implemented across the board, and they need to have senior management buy-in. It's an easy thing to say, much harder thing to deliver against, but you do need to have senior management understanding what data ownership constitutes. I'd suggest it's a central pillar for an effective data governance facility. If you understand what your data is, that's a very good tick in the box. However, unless you know who is accountable for the data, as well as responsible for the data, you're not going to get very far in building up an effective data governance framework whatsoever. So you need to have a clear understanding of what that data ownership structure looks like. And it will vary depending on the size, scale, and type of your business. So there's no simple answer to deliver here. What I can say is that for small or medium-sized enterprises, it may well reside within one individual, maybe two. For the larger medium and truly large and multinational entities, chances are there's going to be a group of individuals who need to be the data owners and need to have very clear description and understanding of what they are data owners of. So you have your data, well defined and understood where it is and what it is. You have policies in place. You have data owners who are checking that things are being delivered okay. But policies in themselves aren't the solution, unfortunately. A policy which sits printed out in an arch file on a shelf in your compliance department's office is not an effective policy. You need to ensure that the policy lives and breathes throughout the organisation, back to staff training, but also it needs to evolve. It needs to change as your business changes and as the business environment in which you exist changes. And for the policy to be effective, that means you need to have a set of rules set aside so that you can understand what the change process for those policies actually is. Who gets to review the policies? What criteria do they apply to that review to decide if anything needs to be changed? And how do you actually get agreement that the change should take place? All these need to be well defined by the data owners and understood by all staff. Because it's the coal face of information in and information out of your business who will know how the information usage changes, not necessarily the data owners as individuals themselves. And another good reason for keeping your policies up to date and reviewed is that the world outside changes. Mimi already mentioned BYOD. Who would have thought 5-10 years ago that personal information or company information could exist in social media? If you have a data governance policy, you need to make sure that it covers today's technological innovations, but the ones that you can't even imagine that are going to happen tomorrow as well, which is why you need to be part of a continuous improvement cycle for your policies. And with that, I'd like to hand back to Teresa and open up any questions.
Thank you very much. We have been listening to Graham Austin of Crown Records Management and also Mimi Dion. And we have a lot of good questions that are coming in here. And just one thing I just want to mention to you right now while this slide is up here. These 5 steps that Graham has outlined is part of a white paper, and there's a link to that paper that's on your screen right now, but I also have a link to that. If you go down into the resources tab, if you click that there, download the white paper we've been discussing today. Again, that'll open up in a new window, and then you can save that off later. But please feel free to go in and download the white paper because there's a lot of additional information that is expanded upon from what Graham has talked about here in these 5 steps for managing for the good data governance. And so right now, I do want to get to one of the questions, just start with some of the questions that have come in. And Graham, I want to start this with you, but certainly Mimi, feel free to join in. What are some tips or suggestions, just exactly how do we get senior management buy-in on this? Because there are a lot of companies out there where someone in the line of business who is frontline doing their work, they realize the importance of this, but they need to convince their colleagues, their supervisors, or just heads of companies. Just how do we get the buy-in from your colleagues for managing your data?
Very, very good question. I mean, the thing that I think is best to focus on is what is of greatest concern to the people that you wish to convince. So if you're talking about board members and very senior members of the management team, I think you need to focus on profit and revenue and cost. If you can describe how either bringing in an information governance framework or improving your current one will improve the bottom line, then you'll have ears. If you talk about it in terms of how it's good for information, probably not going to get, for information management in general, probably not going to get the same kind of attention. So, for example, if you wish to make changes to your current framework with respect to preparations for EU data protection, frankly, 5% of variable turnover is probably a phrase that will get you the ear of the CEO. On the basis of that is a not insignificant sum for a business to lose. So I would start building business. I think it was just building a business case and describing the information management governance in terms of a business case for helping the organization as a whole.
And Mimi, your thoughts on this? How have you been able to succeed to help your clients with this issue?
I have a current opportunity that I'm working on that is incredibly exciting. We're cleaning up unstructured data. And the original sponsorship for this came from, I work in a satellite location. My headquarters is in Europe. The idea of it is sponsored by, I would qualify him as my local CIO, the head of our IT Americas. And thanks to his good sponsorship, we have attacked, literally, our file shares in multiple ways. We have multiple views using a really simple tool that helps us create metadata analysis and visualization, ways of visualization that help senior leadership understand that as we reduce terabytes of data using, initially, we're still in the simple technique stage, and we're about to embark on the complicated technique stage. We are, for every terabyte, say it equals a certain sum of money, we are literally applying cost transformation, as Graham said a moment ago, for this entire satellite office. I have a tendency to look at this very simply, but I think for every terabyte reduced, for example, that's a certain amount of money. Collecting that amount of money, adding all of that up, that's an opportunity to wear my superhero cape and save lives, save headcount, save cost streams, save revenue. So I love the day-to-day challenge of cleaning up unstructured data. I tend to spend the most of my time on it there at the moment because this is a very interesting year in my industry. My industry is oil and gas. So I not only use the project that I'm currently working on to create organically an approach to adding not only my salary back, but hopefully the salary backs of everyone in the IT department, but also as an opportunity to embed good information management, if not information governance principles, like the privacy principles that were discussed to sort of set up the webinar earlier today. I use as an opportunity to communicate with my colleagues as much as I possibly can. And thankfully, the activities of cleaning up unstructured data, it's resonating with everyone across my satellite office, which is fantastic. I mean, there's no greater reward than saying, "Hi, my name is, and this is what we're going to do," and the person opposite me saying, "Okay, God, we're finally going to clean this area of us that's been such a challenge for us. I can barely search on anything, never mind finding something successfully within a reasonable amount of time." So.
Another question that's come in here, a question addressing training. Graham, you brought this up on how important training is. Who should be responsible to train the staff at the different levels, and what to look for in training, with a training partner, whether it's in-house or someone else?
Surely. Again, it's hard to generalize on the basis that different kinds of businesses have their own staff learning structures which work best for them. But I'll come up with a couple of basic things that I think holds true for almost every organization. First, you need to make sure that everyone is included. Inclusivity for this training cannot be understated. Anyone who's going to come into contact with any of the personal information, for example, needs to be able to understand the impact or the negative impact of their actions. So ensure that the folk, for example, who are on the front line, who might not have that much access to computer time but still are involved with personal data, with form filling in, you need to make sure that they get involved. Whether it's done in-house or done by an external provider, either way you need to ensure that the people doing the initial training are appropriately qualified to do so. It's a simple thing to say, but it's important, especially when coming and dealing with an impending piece of legislation, which, given the way that the EU operates, won't bed down until almost after the primary legislation has been signed off by the EU Parliament. You need to have people doing the training who understand how the EU legal process operates so that they can predict what shift and changes will occur after primary legislation before secondary legislation kicks in. Equally, again, depending on the scale of the organisation, training the trainers can work very well. You can make sure that the managers train their direct reports and you spread it out that way. Again, it partly depends on the scale of the organisation. I'd also highly recommend the use of, I'll call them modern technologies, but it looks almost old-fashioned nowadays. I'll say things like your intranet, transcripts of information, video clips, anything which will enable the different kind of learners within your organisation to understand what they need to do, how they need to do it, and most importantly, what the negative impact of them not doing it is.
Thank you. And just to put a plug up there for AIM training, I wasn't expecting to do this so blatantly, but just do be aware on the AIM website we do offer training programs, whether you can do them online. We can also make arrangements with you to do them in person at your facility, and we also offer classes throughout in various cities throughout Europe and the UK, in addition to North America as well. But there are some resources here just as a starting point and as a way to get things started within your organization. I just want to remind the audience of just a couple of things. We are recording this webinar, and it will be available in just a day or two at the Webinars on Demand. Also want to remind you to click the link at the bottom in the Resources tab for the survey. Let us know how we did today. That will open in a new window, and after the webinar is over with, would greatly appreciate your feedback and also to get the suggestions for topics for us to cover as well. Also in that Resources tab at the bottom of your screen, again, just to mention again that there is the white paper that Graham had mentioned. Feel free to download that. And then also there's a link there to download a copy of the slides to get the contact information, not only for Graham Austin at Crown Records Management, but also Mimi Dion. And feel free to reach out to them directly with any questions that you may have or for help with any additional resources. We provide these webinars for you as a resource, and please take advantage of what we can offer to you for this. I do want to try to squeeze in a couple of more questions here because these are really good, and so we're just going to keep going even if we go a little past the top of the hour. Graham, I want to start with you on this question. If you can just touch on one of your points was specifically with the data audit. How do you get started with that? Do the enterprise architects get involved? Who should take up, lead the charge for the responsibility for doing that type of audit, assessing not only where the information is, but what type of information is in there? Can you talk a little bit more on that?
Surely. I'd say the key word is independence here. A fresh pair of eyes inside an independent body is far more likely to be able to see the information and the data that you are holding with greater clarity than that which you do yourselves, on the basis that you will no doubt have filing cabinets that you don't even notice because you just take them for granted because they're just there. And there will inevitably be cases where no one on the floor actually has any idea what's inside those boxes. They're locked. Someone has the key. Who knows whether they're still employed or not. So I would recommend a fresh pair of eyes. Because it's an audit, in the full sense of the word, I think it's also very useful to have some external independence going on the basis that the consequences of the discovery in the audit will have potentially had some significant impact on your organisation, especially if we're thinking of the context of EU data privacy. So you begin by working out the scope of the audit with the organisation that you bring in to carry out the audit, and then you need to let them loose like you let all your auditors loose. Financial auditors, data auditors, they all need to be able to have sufficient scrutiny across your business to reveal everything that needs to be revealed.
And Mimi, anything to add to that?
My experience, I think everything that Graham just said is incredibly important, but my experience has been the opposite. We've leveraged an internal audit function at my current place of business, and we've created a sort of a modest steering committee around it. But again, leveraging the information and from metadata reports, data visualization tools to help explain that to senior leadership, we've created this modest framework to provide not only a way of implementing a data audit, but also to help us create views on the value of the data, the data that we find.
So a couple of good different perspectives here on this. Well, Mimi, in with how you have this set up, how do you define and measure the value of the data? This is another specific question that's come in. My inclination to think is a portion that can be answered in your records management plan. But tell us, how is it that you work with defining and measuring the value of the data?
Yeah, I really appreciate that question. It's by a set of both internal and external criteria. You're absolutely right, Teresa, that, for example, the set of external criteria could be industry-specific retention, the length of time that data is maintained on the file shares is a way of measuring value. But also, of course, in the energy industry, we purchase quite a bit of technical data. So the monetary value, that which you pay for, as well as sort of this intangible calculation of the usability of it, is a formula that we've created in the past year as colleagues transition in and out of, teams transition in and out of our organization. Does the value of the information suddenly drop? Because if a tree falls in the forest, there's no one to hear it. There's no one to use the data. So it's a really interesting approach to and kind of an IT-specific view as opposed to an information governance view. But it's one that my local CIO has espoused, and one that I've been interested in exploring in the past 6 months.
One of the things that we've noticed, again within the oil industry, is that the value, say, of geological data, when the surveys are carried out, say 20, 30 years ago, and organisations looked at potential for drilling, discovered it wasn't any good, so shelved the project, but also deleted the data because who wants to know about that particular piece of land? Well, the answer to the question of what's the value of that data, given that it costs several millions to redo the geological survey, that's the value of the data, and why nowadays it wouldn't necessarily be deleted for 50 years rather than the 20 years. So that the cost of losing the data and replacing it is one way of measuring the value, and it can produce some quite interesting and surprising results.
Well, Graham, you also had touched on what you had called unnecessary data. I've also heard it referred to as redundant, obsolete, and trivial. Things like working drafts of documents, multiple copies when it's distributed to a team, and things like that. So that way, something else is for measuring the low value and deleting out that rot or unnecessary data as well.
Absolutely, yes. I mean, part of the trick is, and this clearly is a non-trivial problem, is there's a distinction between useless but high value and unlikely to be used data. It's almost a black swan problem of not knowing what you don't know and being able to judge which data items are worth keeping for 50 years, which ones should be deleted immediately. It's non-trivial, but it very much depends on the individual needs of the business. If a bank was holding geological survey data for 50 years, you'd want to know why they hadn't deleted it. If you're an oil company, that context means that it's almost essential to hang on to it.
Well, we've gone over our webinar hour here. Very much want to thank Graham Austin of Crown Records Management and Mimi Dion of Mimi Dion Consulting, independent data scientist. Very much want to thank Crown Worldwide, the Crown Worldwide Group, for sponsoring our webinar. Without the support from our solution providers, AIM wouldn't be able to provide you with these free educational programs. So thank you very much, Crown, for your sponsorship of this webinar. We've talked about a lot of different touched on a lot of additional really good topics and had really good conversations that we certainly didn't have time to cover in this hour. If you do go to the AIM Webinars on Demand, there is a full library of previous webinars where we have talked on a few of these topics here and there. Certainly there's also other webinars we do have coming up, and listed on your screen right now are a few that are coming up for you later in April and again in May. So do visit the AIM website and sign up for some additional webinars just to hear your thoughts more on these ongoing conversations just to help you with managing your data well. And so as we are at the end of this webinar hour, I do want to ask each of our speakers for their closing thought or key takeaway from all of the things that we have discussed today. And I'd like to begin first with Mimi Dion and your closing thoughts today.
What a privilege to be with you all today. Thank you so much for your time. I think translating the European Council's comments on the Data Protection Directive sets the stage for functional implementation. They are not finished with their commentary. There will be additional reports that are published by these excellent sources that I mentioned to you earlier today, including statewatch.org. So I look forward to, with interest to watching the activity overseas as it emerges. And if there's anything that we can ever help you with, please don't hesitate to reach out, because it's certainly an interesting conversation that I'd like to continue with you, the audience, as well as Crown. And thank you to AIM.
Thank you, Mimi. And Graham Austin of Crown Records Management, your closing thoughts today.
Surely. The situation with the EU data privacy reminds me of Tammany Hall in the 19th century. Vote early and vote often was the call back then. I think the trick now is to prepare early and prepare often. There is insufficient time as ever with any piece of EU legislation to prepare and get yourselves ready. It's true with EU data protection as much as it is with any other. So don't underestimate the volume of work you as an organisation are going to have to put through. I mentioned 5 easy steps. Please do grab the white paper today to hear some more detail. And needless to say, the devil is in the execution, not in the 5 steps, but we're obviously very happy to help you moving forwards. And thank you, AIM, again. Teresa.
Thank you, Graham. For AIM, this is Teresa Resick, and we will see you next time. Have a good afternoon.